Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Welcome back to the Estate Blueprint, Planning Your Future with Tom Begley, where clarity meets compassion. Attorney Thomas D. Begley III is a certified elder law attorney with more than 35 years of experience helping families across New Jersey navigate estate administration and to avoid those costly mistakes. I'm Evan Mack, and today we're talking about what happens to debt after someone passes away, who actually is responsible for it, and how it gets handled during the estate process. Tom, welcome back, sir.
Good to be here.
So Tom, what actually happens to somebody's debt, when they pass away in Jersey?
Yeah, the answer is, it's one of the murkier issues that people deal with. There's a lot of misunderstanding about, what does occur and actually what's lawful and sometimes what practically occurs. There's a lot of times where there's misconceptions. I mean, I had somebody coming in to go over some estate planning, and they were concerned about some debts that they particularly had. And, their question was, well, when I die, do my kids become personally responsible for my debt? And the answer is no. You inherit assets, you don't inherit debt. On the other hand, the estate is responsible for its debts. So to the extent that there are assets, especially those passing through probate, if those assets are, to cover the claims. So this guy's case, him and his wife are buying a home, and it's actually interesting. They've had they've been in the home for a while. The landlord wants to sell to them. They're going to buy it from her, and they're going to get a mortgage. And their concern is what happens with the mortgage. Well, the kids aren't responsible for paying it directly. On the other hand, obviously with the mortgage, if the payments aren't made or the house hasn't sold, then it would go into foreclosure. But once again, they don't personally do it, but the house would have to use that. I mean, the more common examples, what we had, like, credit cards or, other sorts of debts. I mean, certainly those would need to be, paid, out of any liquid assets that are available.
So Tom, where does the responsibility for paying those debts, fall once someone passes?
So, I mean, they do fall in the estate. And I guess the big thing, Evan, is that there's actually a priority of claims. So, not all debts are treated equally. So the most important debt, which is recognized by the statute, is for the payment of the funeral expenses. That actually comes first before anything. The second is reasonable cost of the administration of the estate. And that typically falls into three categories. Commissions that an executor may take for him or herself for the services they're performing in administering the estate. Reasonable counsel fees for the attorneys that are assisting in resolving any legal issues that come out. The other thing would actually be accounting fees to do any necessary tax returns. Those are considered the administrative expenses. But that gets a little bit interesting after that. So, I mean, there's generally, over the years, historically, where there was two additional categories. One was called secured and the other is unsecured credit. For example, a secured creditor is a mortgage because that attaches to a property. Or on top of that would be an unsecured, but lien. Some secured creditors become secured through obtaining liens. So let's say, for example, when a person was alive, they had a credit card, they didn't pay the credit card sued and got a judgment. If the judgment was entered against the property, be like a hair below collecting on the mortgage, but it certainly would take a priority over, like a credit card where there's maybe a bill out there, but there's, no formal lien that's been asserted. So the thing, and of course the lowest end would be, unsecured, unsecured claims, such as your final utility bills and, credit cards, etc. The big one, which you have to be careful for, is Medicaid. Medicaid has what's called a super lien, and somebody's been on Medicaid benefits during the course of their lifetime, except for the mortgage that jumps above any sort of lien that could be entered against a property or unsecured creditors. So there's a pecking order.
In what situations can a family member end up being personally responsible for a debt?
Very great question. There's one time where you can be responsible, and that is if you are the executor. Well, there's two ones. One is theoretically is, let's say there's not enough probate assets. Let's say, and by that I mean assets are just in the decedent's name that would go through probate. If there a lot of assets don't pass through probate, and that would include life insurance, which is exempt from creditors no matter what. But say retirement plans, IRAs, annuities, jointly held accounts. Theoretically, creditors could go after the beneficiaries that receive those. I have to tell you, though, in 36 years, I have not seen creditors actually do that. I'm sure there are occasions where they have. It's just that it's easy to go, it's mechanically easier, or I guess more sound, for a creditor to go through the probate estate. So here's what happens as far as the probate estate is concerned. When an executor becomes appointed by the local surrogates court, or in Pennsylvania, it's I guess it's the Register of Wills, but here in New Jersey, it's the surrogates court. They used to have to file what's called a notice to bar creditors within 6 months. Because people would forget to do that, the law changed in 2005. And what the law says is that if somebody passes away, creditors have 9 months to file what is called a proof of claim. So let's say, for example, I, had a debt with, Chase MasterCard, and I hadn't paid it during my lifetime. I pass away. Chase has 9 months to file a proof of claim, which is basically a one-page form that says, Tom owes X number of dollars, and that has to be filed with the surrogate within 9 months, and it has to be served upon my executor. And if those things are done, then the executor has to address the debt. Now, more often than not, that if that's probably legitimate and they do have to pay for it, but there's a procedure where they can certainly contest the viability of the debt. So the important thing about that is, let's say, for example, Evan, you were appointed to be the executor of an estate, and you think everything's pretty straightforward. It's all liquid. There's no house to sell, and you start writing checks to, your brothers and sisters, and because you don't think anything's out there, but you do this like 5 months after, mom or dad dies, then all of a sudden a claim gets presented. Well, under the law, if you've released all the distributions and all the estate funds out to the beneficiaries within 9 months, and you could personally, the creditors could turn around and say, that was a negligent distribution, Evan, and you can personally be held liable to pick up the tab. So that's happened. I did see, fortunately, knock on wood, only once where I've had to deal with, but it was a really nice guy. His sister had died. She had 3 daughters. They were all pretty decent, but she wanted her brother to handle everything. Well, he wanted to be, the world's greatest uncle, and he was. But he distributed within a few months, even after we told him not to. And unfortunately, what occurred was there was a final nursing home bill, which was about $15,000, and there was no money to pay it. So the nursing home was really adamant, they're going to come after him. 2 of the daughters were okay. They were able to get back their $5,000 quickly. On the other hand, the third one, she spent money as quickly as they got it. So, there was some, tap dancing, but this guy and also he waived the commission. So, he actually had to pay money to be the executor. So you always want to have a good handle on what that's could be. Now, having said that, creditors can collect anytime they normally collect while you're alive. So for most cases, if you owe a creditor money, and let's say it was due a year before you died, well, they have 6 years from that due date to collect. So 5 years after death, they can still go after you or your estate. The key is that, the law recognizes that the estate shouldn't be held open for years and years and years. So if the creditors can't, get their proofs of claims filed within 9 months, they can still pursue their claims. However, they can't go after the executor personally. And that's really been a big deterrent, because I've seen bills that have come out from time to time, and when they realize they've got to chase down 7 people to, collect, the bill has to be really, really good for them to want to do that.
So, Tom, what happens when the estate doesn't have enough assets to cover everything that's owed?
Evan, the perfect segue. So there is a procedure which is called, it's a verified complaint in order to show cause to bar, to declare the estate insolvent. So it's kind of like a bankruptcy proceeding for an estate. And this does get, this basically, how it operates is as follows. First, you have to wait the 9 months. And then at the end of the 9 months, you file an application, or if the executor files an application with the probate court, and they basically say that John Doe died on X date. When John Doe died, these were all the assets that were owned, and then they'll say like here's additional assets or that may have come in like tax refunds or refunds of homeowners premiums, etc. But this is the inflow to the estate, and then they'll say these are all the obligations of the estate. The funeral costs, the attorney costs, things that have been paid as well as unpaid. You list. And so the idea that you present to the court is, for example, when you count the house, there's, $200,000, between the house and the liquid assets, but there's, $300,000 of, the mortgage and the funeral costs and all the unsecured creditors. So what happens at that point is that complaint is filed with the Superior Court. It gets filed through the Circuits Court, which is the filing clerk for the probate court here. And the court fixes a hearing date and has the executor send a notification of the complaint and what's called the order to show cause to creditors. And if they're not 100% sure who the creditors are, they have to file. It's recommended they file, in the newspaper as well. And then what will occur is that on the return date for that order to show cause, the judge will consider first any applications that are made by creditors responding, and then they'll say, look, okay, we've got X number of dollars, we've got Y dollars of debt, and so we're going to take the assets and use them to pay these costs. And once again, Evan, they do it with the priority that we talked about earlier. The funeral is always paid. And the other is they will make sure that they, pay reasonable costs for administration. And I will say you have to be very careful with this because the executor's commission is calculated at a set rate. However, when you have cases like this, the court can adjust the executor's commission down. I've seen them do that on 2 occasions, where basically, the court said, look, I know the commission, say, was $13,500, which is what it would be for a $300,000 estate, but you didn't have to do a lot of work, and we've got creditors out here, so we're going to chop it down to 8 or 9. So you have to demonstrate to the court that you worked hard to get that $13,500. And also, if you're an attorney, you better make sure that you're not being a pig about your fees, that you're being reasonable. So that's important. It's also important if you're a creditor to make sure that, you get your claim in, because I've been there where the judges said, okay, we have, 8 unsecured creditors and 4 of them submitted their claims and 4 of them didn't file a response. So they'll take care of the 4, but they'll ignore the other 4. So, but Evan, the takeaway is that it's a thing that you should do, because if you wind up filing for the insolvent estate, the court is covering you by saying exactly where all the assets are going to go. And then secondly, because of that, the beneficiaries can't go after the executor for not providing an inheritance. And the third, it discharges the executor and the estate from any potential liability to any creditor. So it kind of closes the book.
How do different types of debt, like secured versus unsecured, affect what creditors can actually recover?
So, well, I guess it's a relationship between the amount of the debt and the amount of the assets that are available. So, because we, occasionally, especially now with reverse mortgages, there are occasions in which, they'll pay the funeral, the funeral gets paid, the, reasonable, fees and costs for administration get paid. But there are times when you add those into a home that somebody had a reverse mortgage that went for a while. I had a case last year. The house was worth about $275,000, but the lender didn't get paid back because this person lived long enough that the amount that was due was about $275,000. So after you paid the the realtor and the the various costs of administration and the funeral, they had to take a haircut. More often than not, the mortgage company gets paid. More often than not, when you see these actions to address creditors, usually the mortgage gets paid, and then let's say there's $60,000 left after you're done paying off the mortgage, but there's $100,000 of debt. If they're all unsecured, typically what the court will do is prorate the payments. Sometimes I've seen a preference go to those who have filed responses versus those who have not.
So what kinds of problems come up when debts aren't handled properly during that estate process?
At the very least, you're going to be getting bothered for 6 years rather than the 9 months in the period. Because really, one of the nice benefits of doing the order for the get the order for the insolvency is that, I talked about that 6 year statute of limitations. You're pretty much barring all those creditors from bothering you for the next handful of years to pay money that you don't have. But one of the problems that you do get, Evan, is when people basically don't handle the debts and they just kind of throw their arms up in the air. You could make an argument if you're a creditor that the executor was negligent and go after them for personal liability. I mean, certainly if it's not automatic that they would get that, but especially once again, if you wind up paying for any distributions out, you're going to be held liable because you should have known to pay the creditors first beforehand. I mean, I'll add one note as I know we need to wrap up, but I have one note, and the one note would be a lot of times creditors are open for negotiation. They believe in the old bird in the hand theory, and some actually, will wipe out. A lot of times, credit card companies if the debts are only a few $1,000s or a few $100s for that matter. I've had families call up the credit card company and, you can't lie and say you don't have any money, but I mean, I've had the case where nothing is passing through probate. So look, there's no probate assets and, they'll write that off. And there's a benefit because once they do that, you're not getting claims in the future about that. And it's one less headache when you're, unfortunately appointed to be an executor, not just for somebody you love, but somebody where the estate's upside down.
Tom, thank you so much for your time.
Evan, thank you very much. Always a pleasure.
Pleasure's all mine. And that's it for today's episode of the Estate Blueprint, Planning Your Future with Tom Begley. If you'd like to learn more about how Tom Begley and his team can help you guide through the estate administration process, visit Begley3law.com. Thanks for listening. And don't forget to like, subscribe to the show, and leave a review if you found this episode helpful. Thank you all so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.